Pleasure for me to introduce to you Dr. Georg Zanger, today's evening speaker. He is a practicing lawyer in Vienna, not completely unknown. And, well, mainly he is working in the field of business law in its broadest sense, competition law.
Good evening, ladies and gentlemen. It is a pleasure to be here today and to have the opportunity to share some of my thoughts with you. The subject matter of my speech is relatively simple. I propose to focus on trademark law and its legal implication for industries in the US and the EU on several different levels. The reason why I have decided to deal with this matter is again quite simple. Following years of negotiations and difficult discussions in the Senate and Congress, the US has ratified the Madrid Protocol in November 2003. The consequences of these legal acts are far-reaching and should not be underestimated. US trademarks can be registered in Europe, designating the community as a region of protection. US trademarks will be treated as equivalent to community trademarks. Conversely, European national trademarks and community trademarks enjoy the same rights as US trademarks in the US market. Instead of registering the trademark in the home state office, the applicant may choose to register the trademark at the CTM office, the Community Trademark Office. This office fulfills the requirement of the protocol. The applicant has only to be a national of a country party to the organization. In such a case, the CTM is the home registration office. The consequences of the ratification of the Madrid Protocol by the US and the European Union are as follows. US trademark holders can designate the European Union as such in order to obtain trademark protection all over Europe. On the other hand, European trademark holders can designate the US. The mere fact that trademarks can be registered by means of one single application in the US and in the EU has certain repercussions for industry. The Austrian Supreme Court has accepted that Austrian courts have jurisdiction on cases involving an existing trademark right. Even though this ruling is based on European trademark, there are consequences for US trademark holders. This means that claims may be brought against US enterprises before Austrian courts on the ground that those enterprises are holding trademarks in Europe. As a result, it is easier to sue US enterprises in Europe based on the jurisdiction granted by the trademark than to sue them in the US. It remains to be seen whether US enterprises may use this possibility to go against each other in front of European courts. This might be a convenient possibility because for the procedure, for example, Austrian law would apply. In substance, the Austrian judge would apply US law. For US enterprises doing business in Europe, this possibility should not be underestimated. To conclude, my practical advice to enterprises is as follows. If you want to register a new trademark, you should be aware of the possibilities offered by the Madrid Protocol. For trademark holders, make sure that your original trademark application is carefully formulated and designed with a strategic goal in mind. Check that trademarks already registered do not undermine your application in the long run. Monitor new trademark applications. Challenge any that may limit your legal interest. To sum up, new possibilities mean new risk. I hope that I have given you an insight into the world of trademark law, and I wish you all the best for your future experience with trademark law and lawyers. Have an enjoyable evening.